Vincent J. Russo is here with another In the Legal Now. And today, Vincent is answering an important question that many of you may have. The question, what happens to me if I lose the ability to make decisions and to manage my affairs? Vincent, thank you so much for being here. Yeah, a lot of people probably are wondering.
That's right, and it's can be scary. I mean, you're managing your own affairs, you want your own independence, but you know, I'm a little off, or maybe I'm having some trouble managing my personal affairs and my financial affairs, and now that individual really is at risk. Their well-being's at risk, their finances are at risk. So it can be a real challenging time for that individual.
Okay, so anybody who is asking themselves that question, what can be done?
Okay, well, if the person lacks the capacity to sign legal documents like advance directives, then we have to talk about a guardianship. And that's where an individual is appointed by a court to step in and manage the affairs of that loved one. And so in the big picture, it's a court proceeding. The laws can vary state by state. In New York, it's an Article 81 guardianship under the mental hygiene law. And it's a law that allows families to step in, bring a proceeding, and be appointed guardian. In some states, it's called a conservatorship. And there are differences in the type of court proceedings depending on the person's particular situation. You know, what type of incapacity do they have, for example, might trigger one to go into one court or another.
Okay, so how does someone get a guardianship?
Okay, so there are a number of steps that have to be taken. The first is to petition the court. So an interested party, typically a family member, needs to file papers with the court. It's called a petition. Then a hearing will be set up, and the judge is going to want testimony as to why there's a need for a guardian. And that individual is going to be brought into court. They're going to attend the hearing. The judge wants to understand their perspective because we're talking about their independence. And then the court will appoint a guardian, if appropriate, and you really need attorney representation. That's really critical.
Yeah. Can't do this, definitely not on your own. So how long does, what we just saw, how long does all that take?
Yeah, that's a great question because it's really going to depend on the type of proceeding. But generally, from the point of filing the petition to the hearing to the court appointment, it could be several months. And so and there could be multiple hearings. Families may not agree on who should be appointed guardian because the court's going to ask three questions. They're going to ask, is there a need for a guardian? What powers should I give that individual? And who should that individual be? Who should the guardian be? So if families disagree, could be multiple hearings, can get very expensive, and it could be 6 months, 9 months. Meanwhile, the loved one's in limbo because they're not able to manage their own affairs.
Okay, but it is up to the judge to appoint the guardian.
That's right.
And once a guardian is appointed, then what are the duties of him or her?
Okay, so it's kind of like, I was thinking about this, it's kind of like getting a driver's license. So you get your driver's license, and it doesn't mean you can get in the car and do whatever you want. You got to follow the rules of the road, right? The speed limit, you have to stop at the stop sign. You have to re-register, right? You have to renew your license. So with a guardianship, it's the same situation. So the court's going to authorize powers. They could be very broad or they could be limited. For example, powers would be to manage the assets, handle bank accounts, file tax returns. It could be as broad as Medicaid planning, which could be really helpful. The individual has a duty and to provide the utmost care and diligence. They have to be trustworthy, loyal. They have to make decisions in the best interests of the individual that they're taking care of. Then there's filing reports. There's an initial report, there are annual reports. It's a job.
Yeah. Wow.
And a requirement to make sure you're visiting the individual. So if a guardian's appointed and they're not local, like a child for a parent and they live in a different state, there may be requirements they have to visit so many times a year.
Wow. Obviously, like you just said, it is a job, it is a responsibility,
Right.
so to get the right guardian. So when, that million-dollar question, when is a guardian necessary?
Okay, so the guardian's necessary when an individual lacks legal capacity to sign advance directives, durable powers of attorney, healthcare proxies, and if they don't have that capacity, now their assets are frozen. They can't move forward in managing those assets. They can't make health decisions. Now a guardian is necessary. Or it could be a situation where someone takes the step to sign a power of attorney, but the agent isn't acting in their best interest, or they're not acting at all. Same with a healthcare directive. So even if those documents exist, if those individuals aren't doing their job, another family member or interested party can run into court and say, wait a second, even though those documents exist, we need intervention here and we need a legal guardian appointed.
Okay, and you've told us before, you have free resources where
Right.
people can find out more about this on your website, right? Just
Yeah.
throw that out again.
Right. A lot of information on the website, but we have these guides. And so we have a guide for guardianships, and it's VJ Russo Law /guides, and it's a complimentary guide, and it walks you through guardianship. It'll be very helpful to someone who's thinking about maybe they need to bring one.
Okay. Vincent, as always, thank you so much.
My pleasure.